Today's conference is being recorded. At this time, I would like to turn the conference over to Chair Rochelle Garza. Please go ahead.
Good morning, everyone. This briefing of the United States Commission on Civil Rights comes to order at 10:05 Eastern on March 21st, 2025, and it takes place at the Commission's headquarters at 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425. Good morning again. I'm the chair of the Commission, Rochelle Garza, and participating in person for this briefing are Vice Chair Nurse, Commissioner Adams, Commissioner Gilchrist, Commissioner Harriet, Commissioner Jones, Commissioner Kirsnow, and Commissioner McIntyre. Will the court reporter confirm you're present? Court reporter is present. Staff director is present, I believe. Yes, I will say yes for him. And I welcome everyone to our public briefing titled Language Access for Individuals with Limited English Proficiency. So last year marked 50 years since Lau v. Nichols, the landmark Supreme Court decision that established language access as a civil right under Title VI of the Civil Rights Act. Today's briefing builds on that foundation and the Commission's ongoing work, including our 1997 Miami report, which highlighted how language barriers contribute to unequal treatment in immigrant communities. This briefing will explore the challenges that millions of limited English proficient individuals face when they are trying to access government services and healthcare. And now, as we examine the current landscape of language access, we must also acknowledge the challenges presented by recent policy shifts, including the executive order rescinding federal language assistance requirements. This order threatens to exacerbate barriers for millions of limited English proficient individuals seeking to access government services, healthcare, and other critical resources. And while some agencies may choose to maintain language access programs voluntarily, the lack of a federal mandate puts essential services at risk for those who need them the most. This commission remains committed to ensuring that all individuals can access the resources they need to thrive. While millions of Americans rely on federally funded programs, too many encounter barriers simply because English is not their first language. This discussion will help identify solutions and reinforce our commitment to breaking down these obstacles so that no one is excluded from essential services. So to fully understand these challenges and explore potential solutions, today's briefing will feature expert testimony from leaders in the field. We will hear from 4 panels that will cover the following area. And on panel 1, we will hear an overview of the current language access landscape. On panel 2, we're going to discuss language access in government services and healthcare. And on the 3rd panel, we're going to hear directly from community advocates about the views on language access. In the 4th and last panel, we will hear from people with limited English proficiency. Now turn to Dr. Rivers, if you would please proceed.
Thank you, and thank you to the members of the United States Civil Rights Commission for taking up the vitally important subject of language access and civil rights, and for the opportunity to brief you today on the current state of language access. My name is Bill Rivers. I have worked on language access at the national, state, local, municipal level, and within the language industry for the last quarter century. Notwithstanding the comments from Mr. Morenoff, and I'm a linguist, not a lawyer, both starts with L, there's a lot of reading involved, but I don't claim any legal expertise. What we understand as a legal framework for language access as a civil right has been fairly well established in the record with Lau in particular and some of the other cases. And there are other statutes where Congress did in fact include explicitly language access as a civil right, in particular Section 1557 of the Affordable Care Act, and the enacting regulations at 45 CFR 92 provide extensive guidance, including notably a prohibition against the use of minor children as ad hoc interpreters and language brokers, absent truly exigent circumstances. I work with an industry that can provide 24/7, 365 over the phone or virtual remote interpreting language access in more than 350 languages. So that exigent circumstance is actually sort of hard to come up with even as a hypothetical. And in most of those languages, if there's a service level agreement in place between the medical provider and the language services company, those 350 languages can usually be obtained within 90 seconds to 2 minutes. So Executive Order 13166 did help clarify the civil rights requirements as they applied to the executive branch. And it had a salutary effect on many state and local governments that were in the late 90s, early aughts, dealing with the incredible diversity that occurs in the United States. As Commissioner Mangpatai noted, there's more than 75 million people who speak a language other than English at home, 26 million of whom are classified as limited English proficient. The Bureau of the Census lists 350 languages spoken in the U.S. The actual number is much higher for reasons that have to do with sampling theory and sample sizes and such, and that's a different thing that I actually used to teach. They miss a lot of smaller communities, and sometimes people will say that they speak English well, and maybe they do, maybe they don't, because the real test is what happens when they show up at the emergency room, at the doctor's office, in the courtroom. Can they be understood? Can they make themselves understood? Can they understand what is going on? Can they give informed consent? Can they participate meaningfully in the court case? There are at least 800 languages we know of. That comes from a recent survey in the city of New York, and that's immigrant languages. And you can add 150 Native American, Asia Pacific Islander, Hawaiian, and Alaska Native languages. So we're talking about 950 or so languages spoken in the U.S. As I said, language access is strongest in the healthcare system, thanks to Section 1557 and the enacting regulations, which I mentioned at 45 CFR 92, and in the federal and state courts. We have a Federal Court Interpreter Act, and most state courts also have parallel acts, and of course, if state courts receive funding from one or another federal agency, then they are subject to Title VI as well, even though they're in the judicial branch of that particular state. Other service providers, we see certainly more uneven patterns, especially the local government level, where school systems and municipal governments may lack the expertise to provide effective language access and may face large numbers of languages in their municipalities and their service areas, albeit mostly spoken by small populations. For example, I was told yesterday that Tulsa, Oklahoma has more than 70 languages in its school system. That's the kind of diversity we're talking about. And again, if we rely on Title VI says no one shall be discriminated against. And also point out that the four-factor test that Commissioner Mangpatai mentioned was developed as guidance by the Department of Justice under Executive Order 13166. So you can still use it, but it's just no longer official guidance. At least that's my understanding. And guidance, of course, is guidance. There are lots of cases where it's very hard to find interpreters. Languages like the indigenous languages of southern Mexico and Guatemala, Zapoteco, where you might need a Spanish to Zapoteco interpreter and an English to Spanish interpreter called Relay, and that provides additional barriers. Certainly, and then another case that I just want to highlight quickly is that during natural disasters, often the local talent, as it were, the people who would be relied on locally for language access and for all sorts of other services during a natural disaster, they may well be victims of the disaster itself, and so that poses additional challenge. One of the things I wanted to highlight too is that unlike the provision of language access is much more like the provision of access under the Americans with Disabilities Act, in that it requires affirmative actions be taken. I mean, not affirmative action per se, but you actually have to do something, and you have to expend resources, and that can pose an additional threshold for entities who are, they're public agencies. The budgets have to pencil out, and so it's always a challenge to find those resources. Whereas refraining from discrimination, I mean, there are likely costs for that too, but it's not so obvious or so easy to put into a line item. I'll wrap up a little bit with the question I get very often as, well, isn't AI or machine translation going to solve this? And AI can be seen as an outgrowth of statistical machine translation, just on a much larger, more complex scale. It still makes mistakes. There's a civil rights complaint filed against the state of Virginia for a mistranslation on their website during the COVID crisis. The vaccine is not mandatory. It was translated into Spanish, the back translation of which would have been the vaccine is not necessary. That is a significant difference. It wasn't caught. There is regulatory language around machine translation that requires review by a qualified human translator in the healthcare context. We also have seen, since the recension of the executive order, at least 7 federal language access contracts have been rescinded. This is probably not entirely attributable to the recension of the executive order, but also to DOJ, and it begs the question how those agencies then engage with those citizens, residents, whether they're here legally or not. The recommendation that I have made in my text is that the Commission should strongly consider whether the protections that were made explicit by Executive Order 13166, binding only on the executive branch as we understand, whether that would be a subject for legislation. Thank you.
Thank you so much, Dr. Rivers. We're coming up on time. Last question to Commissioner Cursino.
Thanks very much to all the witnesses. It's just a generalized question. Anyone can answer. To what extent do you think the advent of AI may reduce or obviate many of the issues that have been raised here this morning?
So I'd be happy to start that and pass it on to my colleagues. One of my many volunteer roles, I'm chair of something called the Stakeholders Advocating for Fair and Ethical Use of AI in Interpreting. Noted earlier that AI is essentially an outgrowth of machine translation. There are now voluntary guidance published by the Coalition on the adoption of AI, as well as some very good empirical research on the use cases. So where is AI appropriate? Where is some support from AI that might improve the interpreter's productivity? Where is that appropriate, and where is it completely inappropriate? So, for example, I've briefed a number of state AOCs and state Supreme Courts in their work on considering whether to integrate AI in terms of language access. A question that I have thought about asking but have not yet had the nerve to do is, would you replace yourself, Justice Garza, with AI as the presiding over the case? Because what Professor Nam talked about, there's still, it's not just the word for word. AI is neither artificial, it's made by people, it's not intelligent, not in any way that a priest or a neurologist would recognize as intelligent. And all it's doing is creating a stream of text. Whether that text is accurate or appropriate is not always the case. It will, much as machine translation is used very widely in the translation localization industries, but it's almost always with a human in control. There are use cases where it's appropriate, but anything, you're not going to machine translate a deposition. You're not going to have an AI interpreter in a court case. And the consequences of mistakes and then the accountability for those mistakes. Who's paying if there is a significant medical injury because of a misinterpretation by AI? There's clear accountability when that happens with a human interpreter, and that the interpreter has insurance, or the company providing the interpreter has insurance. What happens with the AI? Who's responsible if we rely on it? Now, I'm an American. I love my technology. Prying this out of my cold dead hands, right? Although my daughter keeps telling me to put it down at dinner. She's right. We love technology. We love easy solutions, but sometimes, the better solution is the one that's worked for more than 70 years.
Well, thank you for adding that. That's a lot for us to consider. We just did a report recently on facial recognition technology, so